Hi, everyone. Welcome, and welcome, Mark. Mark Kennedy is here tonight and kindly agreed to speak to us about estates and taxes, which doesn't sound exciting, but I think I think for most of us dealing with it, it's going to be a good thing. So
Thank you.
So we really welcome you, Mark. Before we start, actually, I should just formally make an apology to Mark because this is, I thought I knew what CPA stood for and the designations abbreviations, but this is where the Google search is dangerous because I looked it up and I gave him it was the wrong interpretation of the abbreviation. So I'm going to ask Mark to kindly introduce yourself and tell us yourself, your background and your designation, and that would be great. So I guess one more thing, and are we recording tonight's session as well? Yeah. Okay. So just so everybody is aware, we are recording it. So it will be posted and made available publicly later, but just in our question and answer sessions to, again, keep in mind that this, some of these is going to be posted for the public. So please be conscious of that in terms of sharing anything that you don't want to be shared that's personal about yourself or your resident.
Great.
Okay. Yeah. And
the show can
and
start.
yours, Mark.
Okay, thanks.
Yes.
No, my name is Mark Kennedy. I'm a chartered professional accountant. I achieved my designation back in 1993, so I've had it for a few years. But I've been working in this area of public tax accounting for almost 45 years. So I go back a long ways with a lot of changes and adjustments and that. So I've had a lot of experiences and there's lots I've seen. And I can guarantee you there's a lot of work that had to go into fix problems that have occurred because people didn't interpret things right, or they didn't have a will in place when they passed. In fact, I have one that came in last week that I'm working on that was like that. So it's an area where people want to avoid it because they think if they deal with it, it's actually something that's going to happen. Well, I'm sorry to disappoint you. It's going to happen whether you deal with the paperwork or not.
Yep.
A lot of the times when I'm having discussions with clients about estate planning and they want to have the perfect plan, my first question to them is, can you please provide me with your date of death?
Yeah.
And there's a great reluctance to provide that information. So that's what makes it so difficult sometimes to come up with what's the best option to do or what the plan should be. And of course, everybody's family is different. Just let me share my screen here. Let's see. There we go. So we're going to look at very briefly what is estate planning, the estate planning process, what tools and strategies there are. I won't go into identity theft and fraud or much into tools and resources, but those first three are the ones that I'm going to be focusing on for the most part. So estate planning, what is it? Well, it's like it says here, exactly that, the process of creating a plan to distribute your assets during your life or upon death. Notice both parts are there, before death and after death. And the process is designed so that you are deciding how to take care of the people that you care for and the things that are important to you. why do it? Well, it makes sure that people that need to have your support after death are cared for. It does minimize, in a lot of cases, potential family disputes. It lets people know what's important to you and how it's supposed to be taken care of. The big one is it helps you minimize the costs of doing so and the taxes related to it. And for another group of people, it brings in the issue of peace of mind. So things are going backwards for me here. Okay. Components and goals of estate plan. The big one is a properly drafted will, and I can't emphasize the word properly. Insurance can play a piece in it. There's various arrangements that can be done as a result of setting up a will. You could end up with a family trust being created. You could end up with a spousal trust being created. And this could be done during the lifetime or after death. And if you have a small company with other partners involved, there could be a shareholders agreement. The process is very straightforward. And then it starts with determining what your objectives are. I had one client who had 3 sons. One died in a traffic accident. The other one became a drug addict because of it. And the third son was autistic, severely autistic. And so the father decided he wanted to manage his estate so that his objective was everything went to the son who was autistic and nothing went to the son who was a drug addict. Obviously, the one who had passed away was out of the picture. And so once you've identified what the objectives, like this one client did, it makes it easier to come up with a plan to be able to go ahead with that and what should be in the will and what shouldn't be in the will. Okay. The second thing you need is an understanding of your current financial situation and where it could go from there. And there's a variety of strategies and tools that are available to help you manage that. You end up with then developing a plan. The important part is to implement the plan. And then you got to follow up and keep it current. Okay. Tools to consider. Power of attorney. What's pictured here is one from the province of Ontario. We don't have a form like that here in BC. It's usually made up on a specific format that notaries or lawyers can do. There's wills, there's joint accounts. Okay, gifting is something to consider. Trusts are another way that a tool that's available, and some people use life insurance. Power of attorney. The focus here is a legal document that allows someone you designate the power and authority to act on your behalf. Can be anyone you trust, does not need to be a lawyer. Okay. And you can even put limits on what they can do or be very specific as to what they have the power of attorney to deal with as well. Generally, that's not something that's looking for. Now, all power of attorneys become invalid upon the death of the person who issued it or authorized it. And here in BC specifically, all power of attorneys should be in land title form. Well, what does that mean? Land title form is a specific format for the signature block and date it was signed.
Great. I guess I know that one.
So that so that the land titles office can process something when it's being authorized by someone who has power of attorney. If it doesn't have that land titles form, your power of attorney, while it is valid, prevents you from being able to have items dealt with if your power of attorney dealt with at the land titles office. So you could have a power of attorney from Alberta. If it's not properly laid out like it would be required here in BC, and you're trying to transfer a piece of property from BC, it would not be accepted by the land titles office. So that's something that should always be considered. And a power of attorney always comes in handy when you are been away for an extended period of time or when you become incapacitated. And that can happen in a number of ways. And those of us who are dealing with our parents or siblings who are at Fairhaven can understand that and can appreciate that if power of attorney has been arranged, then there are things that we can do. Okay. There are generally here in BC 2 types of powers of attorneys. One to deal with legal and financial issues or for property. And the other one is to deal with healthcare decisions. It's usually in BC referred to as a representative agreement. And it details guidance for those who have that authority to make decisions on an individual's health care. The other one, which is for legal and financial issues, that's usually all that it's covered for that. Dying without a will. This happens more often than people realize. I think in the last 10 years, I've had about 20 individuals who have died without a will. Now there's a lot more than that. It's a higher percentage of the population than that do not have wills. But the result is it can be it can increase the cost, especially if they have any assets, to be able to get someone to have the authority to deal with it and dispose of it. It takes longer. And you could have 2 people who want to be the executor of that type of an estate, having to battle it out in the court as to who's going to get it. And the courts have to make that decision. So it can be very unpleasant. And it also leaves you no say over who gets what your assets are. Because under the Wills Estate Succession Act, if there's no will, the distribution of the assets go along a very specific formula, depending on whether you have a spouse or a spouse with kids, or if there's no spouse and kids, then it would go to your parents. If your parents aren't around, it goes to your siblings. If they aren't around, then it goes to your nieces and nephews. And of course, if there's nobody around, it goes to the Crown. Okay? And because it may take a long time, taxing issues could be a problem. Okay? Making your will. Most law firms have a 7 or 8 page questionnaire for you to fill in that helps you identify what your objectives are, who your executors might be considered, who's going to get what out of the will, and what your assets are. Okay? And it's always good advice to update your will every 3 to 5 years. You don't have to do anything, but you take a look at it to make sure that it's still relevant. And after every significant life event. The oldest will that I've had to deal with was one that was prepared in 1942 by an individual who had done it as part of his requirements to go overseas during World War II. So that will was over 80 years old and was still valid today. Okay. selecting an executor or an executrix. Name one in your will and also a backup. It's always good to have a backup, especially if you're choosing someone that's the same age as you. It's always good to have somebody who's younger. Okay. Responsible for executing your wishes. So it should be somebody who understands the way you're thinking and why you did what you did. It's not an honorary position. It's not something that should be considered, well, he's my favorite person, or it's Uncle Joe, and really it should be him who does it because I got to honor him or something like that. No, you need to choose someone who's competent, knowledgeable, and trustworthy. If you appointed someone to be your power of attorney, that may be the person you choose to do your will, or you be executor of your will. It's always a good idea to get there, to talk to them about them, let them know what's happening, because they have changes going on in their life too all the time, and they may want to take an extended world cruise or something like that and won't be available to deal with stuff should you happen to pass away while they're gone. Okay. They are not bound by that. Even if they agree to it, they're not bound by it. They can refuse it when called upon. That's why you would have a second or an alternate identified. We did have one will where there was no executor identified. And again, that's better than no will, but again, anybody could apply to be the executor in that case, and then they would distribute everything according to the terms of the will. And there is the ability for a fee to be charged, anywhere from 2 to 5% of the value of the estate, approximately. Okay. This is something that I have difficulties with clients accepting from time to time, is that the tax department, based on their interpretation of the Income Tax Act, and one that's generally held, is that when certain things happen in one's life or use of an asset, you're deemed to have disposed of the asset for tax purposes. Okay, so when you die, you're deemed to have sold your asset. Even though ownership actually hasn't been sold, but technically it has been sold from the point of view that it gets reported on your date of death return or your final return, and then the asset is transferred to your estate. So you're deemed to have sold it to your estate at whatever the fair market value is at the date of death. Okay. Now, there are provisions within the Act that allow for certain situations where it can be transferred from one spouse to the other with no tax consequences. But in most cases, when there is no spouse, it's deemed sold and transferred at fair market value. And capital property does include more than just land. It's investment accounts, it's bank accounts. It could be a right or a thing. If you own the rights to an invention, that could be part of it. So it's quite all-encompassing as to what's included. And a lot of the times now we have a lot of people who bought a piece of property in the 1970s or 1980s. I got some who bought it in the 1960s. And we all know what's happened with property values in the greater Vancouver area. So something they may have bought for $20,000 in 1960 is now worth $3 million. So if it's not their principal residence, that's a hefty tax bill to be paid. Okay. The filing deadlines. There seems to be some confusion with some people on this. When you die, you're required to file your final tax return by the 30th of April of the year following your death. The only exceptions to that is if an individual dies between the 1st of November and the 31st of December, the last 2 months of the year, the tax department is willing to give an extra 2 months. So if you died on the 2nd of November, the tax department will give you till the 2nd of May to file your final tax return. Doesn't sound like a lot, but that's the extent of their generosity. Obviously, if they pass away in the early part of January, then you've got a whole year before you have to, or more than a year before you're required to file the final personal return. A lot of people have an estate which requires a trust return to be filed. So if you died on the 10th of January, for example, your personal tax return would not be required to be filed till the 30th of April, the year following the death. But the trust return would have to be filed 90 days after the anniversary of the 1 year anniversary of the death, which would be the 10th of April. So the trust return would have to be filed before the personal return would be filed. If you're feeling like it's complicated, welcome to my world. Cash needs and expenses upon death. These are typical. They need to be considered and funded. There's a variety of, that's something you should consider and work out and know ahead of time so that people aren't scrambling to try and figure out how to do this after you pass. If you have your own principal residence, there's usually no taxes associated with that. So it's not usually a big tax burden. But if you have a large RRSP, and I've seen this happen too often, $300,000 or $400,000 in an RRSP, it gets reported on your date of death return. The $400,000 goes directly to the beneficiaries, but the estate has to pay the tax bill on that $400,000 worth of income, which could be $100,000. And if that's the only money the individual had, then there's a problem on how that's going to be paid. And the tax department has tools to make sure it does get paid. Joint accounts, joint ownership. Generally speaking, in legal terms, if you have a bank account or a piece of property in joint names, right of survivorship is usually attached to it. You go into the bank with the death certificate, you take the other person's name off the account, and that's usually the end of it. Not according to the income tax people, because the income tax people deal with all property with two forms of ownership, one being legal ownership, the other one being beneficial ownership. And you could have an investment account, for example, that has your name on it and a child's name on it, and you pass away, they go in and they have your name taken off. But all through your lifetime, you've been the one who's been reporting all the income and the gains or losses on your personal return. So the son, the child's name who's on that account, has no beneficial interest in that account for tax purposes. So the asset is deemed sold at the date of death. Taxes would have to be paid based on the fair market value of that account, less what it costs to acquire that, and all income up to the date of death would have to be reported on the date of death return. So And that's true with any asset where you have your name on it and somebody else's name on it. You need to be very careful from income tax point of view, as opposed to a legal or a law side of the house point of view. They're treated very differently. And we have lots of discussions in my office between myself and the lawyer and our clients on what has to be done in each particular case for income tax purposes, because it may be at cross purposes to what the client wants done for legal purposes. Gifting assets before death, that's always a way to avoid taxes at death, but the only gifting that avoids taxes is cash. If you gift a piece of property to somebody, whether they're related to you or not, you're deemed to have sold that property at its fair market value and have to pay the tax on it. So, like gifting to charitable purposes, like if you want to gift a piece of land, there is the ability to give shares to a charity and not have to pay capital gains tax on it. But there have been recent changes to what they call the alternative minimum tax calculation, and that may complicate being able to give what you thought you could give, because it requires taxes to be paid in some situations. Trusts are a common vehicle that are used to help manage the assets of an individual. The Income Tax Act itself has two that it sets up. One is called an alter ego trust. The other one is a joint spousal trust. The only beneficiary for either of these trusts can be the individual or the couple. Nobody else can receive a benefit from this trust until after they've passed. It's probably a good idea to go talk to your tax accountant about these things prior to setting them up, but they're a very useful tool for managing your assets should you become incapacitated, because you would identify who the trustees could be for it. We had a situation a few years back where a client had given his power of attorney to a neighborhood kid. He'd grown up and was an adult at the time, but he wouldn't give it to his sons because he knew that they would just spend the money. And they weren't that fiscally sophisticated either. So the neighbor boy took care of everything for him. In the process, after a few discussions, he decided to set up an alter ego trust with his power of attorney, and we did. And he named somebody else to be the trustee of that fund should something happen to him. A year after he had done all that, he was working out at the airport, was up on the wing of an aircraft, slipped and fell off, banged his head off the pavement, and died from his injuries. So if he hadn't put in place this alter ego trust, all of the funds would have been turned over basically for the kids to take care of. And again, there was a reason the father didn't want that family situation to work out that way. So, and we used an alter ego trust to be able to do that and manage his assets and care for him. Yeah. The benefits of the trust are listed there. It can be helpful to manage things for a minor child or those that are severely disabled or impaired. You can control your own assets without owning them. Hard to understand that sometimes. It can shield your assets from creditors because the trust owns it, not you. And there is the possibility to reduce taxes depending on what the assets are and what the objectives have been for setting up the trust. The issue of privacy, this was prepared a number of years ago. Privacy was a big issue and trusts allowed for that privacy to exist. But effective with the 31 December of this year, a lot of that privacy information will now be going to the government because they're requiring a lot more detailed information for all existing trusts and for what they call bare trusts. Trust returns have to be filed every year, just like a personal tax return. They have to be filed within 90 days of the year end. All those trusts that are produced or made while a person is still alive automatically have a December year end. So the filing deadline for trust returns is 90 days after the year end. So in most years, it's the 31st of March. For leap years, it's the 30th of March. It's now an estate, when it's formed or created because someone passes away, is entitled to the first 36 months using a graduated tax rate, similar to what's done on personal returns. After 36 months, they have to switch over. Usually when I'm doing them, we do it on the anniversary date of the death. Once we reach 3 years, we have to switch them over to a December year end. And everything on those trust returns is taxed at about 50%. So you want to, wherever possible, to deal with disposition of properties and stuff within that 3-year window after death, because anything after that, the tax bill goes from 25 or 30% up to 50%. It can be quite costly. This is an additional slide that I prepared just to remind you that you have the Income Tax Act creates alter ego trusts or joint spousal trusts. Both parties have to be age 65 or older to be able to use these ones here. All the assets of these trusts are solely for the benefit of individuals, and all assets in these trusts transfer outside of probate. In British Columbia only, the Wills Estate Succession Act is the governing statute for wills and how they're probated and processed. And it also allows for any named or unnamed eligible beneficiaries to challenge the will during the probate process. Any named or unnamed eligible beneficiaries have to be identified by the executor. So, in my example I gave earlier, where there were 2 sons alive at the time of his passing, one was a drug addict and one was severely autistic, and he wanted everything to go to the son who was autistic and nothing to the son who was a drug addict. Both would have to be identified and given a copy of the will for probate to happen. Obviously, the son, who was a drug addict, would realize he has no access. He's not getting anything from the will. It would only make sense for him to challenge the will, to say, look, I need my fair share. And that can take anywhere from 2 to 4 to 5 years to go through the court system to be resolved if there could be a in that particular case, because one was autistic, the public guardian's office, the public guardian's office would become involved and would be restricted in terms of trying to prevent the other son from getting involved. It would just get messy, plain messy. There's life insurance. Depending on your situation, I find most people don't need it, but there are cases where life insurance can play a role. So, tax-specific tips. Review your estate plan regularly. There's ways available to you to freeze the value of your assets and arrange for funds to be set aside to pay the tax. Consider using life insurance to help pay the tax. You can partly or completely freeze the value of your estate, and weighing non-tax benefits of using trusts for post-mortem tax planning. Key ideas: remember, there's a power of attorney, name an executor, maintain a will. A good estate plan will help minimize or avoid your tax on estate and your probate fees. And here in BC, that can be, it's 14,000 per million, approximately. Okay. So that's all I've got to say. I'm open to questions. There.
I have three questions, so
but
Somebody's got an, oh, Shirley, you got both on. Oh,
I've got both on, sorry. But I'm happy to, just do it one at a time. So I don't want to hog all your time for questions. So I'll let.
oh, my whole day goes like this. People always are asking me questions. So.
I have three. So the first one, I wondered when you mentioned that we need to use the land title form for the power of attorney.
Yeah.
Is part of that, it just reminded me, but do power of attorneys get registered just like land titles are registered?
No, they're not. No.
Okay.
It's just a format for the signature block and the date page as to how it's laid
I
out.
see.
And I'm not sure if it's to do with scanning the information in or why they want it that way, but that's, the land title people are very rigid about that. And I've heard of cases where they've rejected transfers because it wasn't done in using the right format on the power of attorney. Yeah.
Okay.
Yep.
Okay.
Joy?
Joyce.
Yeah, so thank you so much, Mark. I'm glad to join in today because I'm working with my parents, and we were hoping to find a way to avoid paying all of the taxes and property transfer of their properties. Now, one of the things that my parents are hoping to do is to allow their estate to go to their grandchildren. So I think by you're listening today, I think we need to pursue setting up a trust or something so that upon either of their passing, the trust can help to maintain, the needs of the remaining spouse, make sure they're cared for and everything. And then I don't know, can we eventually give it to the grandchildren without paying all those millions of dollars in taxes?
Oh, the simple answer is no.
Oh,
Okay.
Darn.
It depends on what the mix of the assets are. Okay. If all you've got is a principal residence, okay.
yeah.
There's usually not much tax associated with that once you pass. Okay. The issue becomes, say, you bought it for $200,000, and when you pass away, it's worth $2 million. So there's an increase in value of 1.8 million. You can claim principal residence on the property, therefore you don't pay any tax on that. But it goes into your estate at $2 million. Now, if it's in the trust and it's for the benefit of the grandchildren, some of them are not of age.
Right.
That's a concern. I don't know what the ages are, but it's a flag that goes to me. So the question is, are you going to sell the house and take the money and invest it?
I guess it all depends on when that happens, right?
Okay.
Maybe.
So these are questions that need to be looked at, as to, are the grandchildren going to get the house? because
That's
obviously.
that's the want, you know, and the, I guess the want of the grandparents is that the grandchildren get the asset, whether they decide to live in it or not, the grandparents don't care.
Yeah.
But they want the grandchildren to have it.
Yeah. See, in my situation, I only have one grandchild. So it's not going to be a bun fight as to who would get the house.
Yeah.
It's just the one grandchild. But if you have 10 grandchildren, you got a different issue.
Only two. There's only two to deal with. So
Well,
yeah.
when they get to be adults, they might not like each other. So
yeah,
you
they
might
won't
have to
live
saw the
together.
house in half, or line down the center, or something.
Well,
But
and so I guess, thinking about that, that's why I wonder if a trust is the way to go, because then the trust can say, well, I don't care if you guys don't like each other. The trust controller will say you
Yeah.
each get 50%, and that's what it comes down to.
well, yeah, but I would think in the will or in the trust document that's produced, there's some direction as to how that trustee is going to manage that property and dispose of it, or how they go about disposing of it if they need to. So you probably need to spend some time talking with a lawyer and a tax accountant about it.
Okay.
Just to see what all the issues are and be able to develop the plan more fully. But whatever you do, whether it's through a trust, an alter ego trust, or joint spousal trust, or you don't do anything and just want to probate it, the amount of tax that has to be paid at the date of death is the same. Is basically the same. It's not that one helps reduce probate fees, the other one doesn't. That's the big difference. Okay. Yep.
So we need to sit down with a lawyer.
I would recommend that. There's too many variables that have to be looked at. And yeah. And of course, if it's done through the will and the kids don't like it, even though it's going to the grandchildren, they could want to vary the will.
Oh.
Okay.
Yeah.
Yeah.
I just am assuming that everyone gets along and it's going to stay like that.
You should
Very
come to my
optimistic.
office sometimes and be the fly on the wall.
You're being very optimistic. Yeah.
It comes with the name. Everything's always happy and
Yeah,
joyful
well-
in my world, and everybody gets along. It's lovely.
Yeah. Well, take a look at, Sue and I, our family, there's 5 of us.
There's
My
9
mother
of
got
us.
remarried, and now there's 9 of us.
Oh gosh.
So
We have a trust.
it gets complicated,
Yeah.
and it's easy for one of them to get their nose out of joint.
Right.
That's all it takes. Yeah. Not that they would, but
Right.
the more people you have involved in this process, the more complex it becomes.
Yeah.
Yeah. You had 2 more questions, Shirley.
I did. So if no other takers, I will ask my second, which is a bank. Well, I worked in the banking industry, so a lot of people I come across, they suggested that if I have named the beneficiary on all of my, different funds and investments that I have, that basically it's not as essential to have a will or have to spell out considerations for those who are beneficiaries. Is that true?
Okay. Depends on what all your investments are. The only ones that have beneficiaries on them are registered plans. So that's your RRSP, RRIF, and your TFSA. Okay. Unregistered plans, I see some of the smaller investment companies doing that, not the bigger ones. But there's no requirement. They can't honor that because if there's no will, then the assets form part of the estate and have to follow a very specific distribution model. So I would say it's inaccurate to the point that it is for registered plans, but not for unregistered plans.
Mm,
Yeah.
okay,
Yeah.
that makes sense.
Now, joint ownership is a different issue and has different
Mhm.
complexities to it due to beneficial ownership and legal ownership differences. But
Right.
okay.
Okay, thank you. That makes
Yeah.
sense to me.
Okay.
Mhm. So okay. Any other questions? And I'm going to ask my third one. What if in the case, and you talked about capital property and assets and all of that at the time of death, what if there is a loan outstanding or a promissory note that is outstanding for the deceased? Does that transfer over to whoever's named in the will as well?
No, it has to be, okay. If the individual owes a promissory note, say to his brother, okay,
Mhm.
and all his assets are going to his own children,
Mhm.
that note needs to be paid off before any distributions are made to the children, to the other beneficiaries.
Well, I meant the other way around, sorry. So if there is an outstanding promissory note that let's say one of the children owes the deceased,
Yeah.
then does then automatically turn over and
No.
Oh,
Well, it's usually when there's a situation like that, and the lawyer I work with knows it exists, there's usually some instruction in the will as to how to deal with that. And usually the comment is made something along the lines of, this particular child's share is reduced by the amount of this loan. And so everybody else, so all the total assets go in, everybody gets their share, and the one share is reduced by that amount of that loan. Okay. And so the others get a little bit more because of it. Okay.
can that loan be called right upon death, or can the others choose to keep it going and continue to collect the interest, for example, from that?
It depends on what the instructions in the will say. So like I say, if there is something like that and the parent wants that not to be extinguished before the terms are up, like there's principal and interest being paid and it's supposed to go for a certain period of time, then the problem is it would probably keep the trust alive,
Right,
until it is paid off. That would be a concern I would have if it wasn't extinguished beforehand. Usually, like I say, there's provisions in there to extinguish it using the one's beneficiary, one's person's share to pay it off. Yeah, but the issue is, if it stays beyond the 3 years, of course, all the income that's being earned gets taxed at 50%. So that means everybody's contributing to that 50% tax liability. Okay, they may get the benefit of the interest, but they're losing out on all that tax. So,
right, okay.
yeah.
Oh boy, okay, so I'm sorry, it is a very specific situation, but so in that case, we should get, no?
No,
Okay.
it's not. No, it's not unusual. I have seen it on a couple of occasions, and trying to work your way through how to get it done. I mean, I did one estate where I couldn't sell the house to distribute the benefit of all the beneficiaries until the dog died.
Oh, wow.
Okay. And in this day and age, pets are becoming much more important to individuals. We just finished doing one where the client died and she has a bunch of birds. And so she doled out the birds to different people who said they would take care of them. These are parrots, so they're 80, 90-year livers, live long. But she also doled out some money to help pay for their costs. So that complicates how you do the distribution of the will too. So
Hmm.
I think we're going to see more of that in the coming years, of pets being cared for before children.
Huh, interesting. Okay.
Yep.
So the person we should consult, or should we be consulting a tax accountant like yourself, or a lawyer, or who would be the best to
Well,
reach out to?
where in my practice, I'm co-located with a lawyer who does estate work, and we've done that intentionally so that we provide one-stop shopping for our clients, and we both benefit from each other being there. Like, there's a lot of crossover. After being together for over 10 years, working together, we've got a lot of crossover. But we can get answers back and forth on legal issues, on tax issues, to help clients, even if they aren't going to become a client of ours. So we try and save time that way. But a lot of the times you need to have the lawyer and the accountant talk. We're working on an estate plan for a couple of children on behalf of their father, who just gone into a home, and he's got some property in Burnaby here. And how are we going to manage that? So we've had a couple hour-long discussions about the whole affair. We've come up with a plan as to how it's going to be taken care of, and how it's going to benefit them and their circumstances. So I end up being the architect, so to speak, to come up with what needs to be done. And we pass it on to the lawyer to execute it and prepare all the legal documents from the alter ego trust. I think in this case, we've got the alter ego trust, we're doing a corporation, and we've got some tax-free rollovers we're dealing with. So there's a lot of legal paper that has to be done, and a bunch of stuff that's to be filed for income tax purposes as well. So we'll be dealing with that. But again, that took at least 2-3 hours of discussions and planning, and that's over. I think we met in September. We just met a couple of weeks ago, and we're just now turning it over to the lawyer to have them do their part. So sometimes it's easy, it's straightforward. Other times it can get complex, and you have to allow people to think their way through it so that they understand it. I don't like implementing any of the plans I develop if the ones who are going to be managing it don't understand why it's being done the way it is. So, yeah.
Bottom line is plan ahead and never too early to.
No, I was at Kwantlen Secondary yesterday teaching a class on financial literacy and budgeting and savings, and that was the same discussion there as here. Make a plan. When you execute it, take time to compare, see how the execution is carrying on. It's not identical to this, but it's the same concept. Make a plan, and you check it every so often. Is the plan still going to work? Or if things change so much, I mean, you may have 4 kids that are all capable of taking care of themselves and managing everything, and oh well, I can divide it equally amongst all 4 kids. All of a sudden, one of them trips and falls on the ski slope and becomes a quadriplegic. Well, obviously, he's going to need a lot, or that one's going to need a lot more care. Maybe you need to reassess the family's support for that one individual. You know, it's amazing what little things can trigger the way you want to look at things and how you want to do them. That's why you need to review your plan. Yeah.
Good advice. Thank you.
Yeah. I know when we're dealing with our aging parents, if they haven't got all their paperwork in place, that's a whole different issue as to how to manage that and care for that. And to if they haven't issued power of attorney, or they haven't done a representative agreement, that's a whole nother aspect of this estate planning that we didn't even touch on, that involves conservatorship. And that's an
Right.
expensive process to go through to be able to get it put in place. So that, yeah.
So we can make that a whole new set and a whole other session with you then. Is that what you're saying?
Well, I've had to do a couple, but yeah, no. Like I
Okay.
say, in
Well,
almost
either.
yeah.
Well, I'm thinking if we have no questions, either everybody has already done everything that you've suggested, or we haven't thought about it at all. So
They're
I
overwhelmed.
hope that.
Overwhelmed is quite often it. They're not sure
Mhm.
what questions to ask, and I have clients who come into the office and we begin the conversation with, "I don't know if there's anything I can do." Yeah.
Right.
Yeah.
Did someone? I heard somebody's voice there. Did somebody have a question? No. I think at at a minimum, it gives us lots of food for thought. Basically, when you think about all the different aspects we have to consider, and if we haven't even started a conversation either with our loved ones or with our siblings. Like there are 9 siblings, 8 of us are surviving. So, and I'm 10 grandchildren. So I'm just thinking about the complexity of all of that. My mom, we're to think about what to do. So
Yeah.
So, Mark, you mentioned that the power of attorney and the sort of the representation agreement, but you didn't mention the advanced health directive.
The healthcare representative?
Yeah, because I think when
Yeah.
my mom was diagnosed, she already had a representation agreement, but they said that we needed to get advanced health directive. So in terms of the end of life.
Yeah,
right?
that's usually a paragraph within the healthcare representative.
Yeah.
Yeah, we have that in my mother's, and it covers off very specific. If this happens, this is how I want it taken care of. If this happens, I think mom's got what, 4?
Yeah.
4 of them listed there, and how we're supposed to deal with it.
These are
I'm not getting into specifics, but
Yeah.
it's usually a paragraph within the healthcare representative that deals with that. If they haven't put it in, it doesn't mean that my understanding is that if you have the healthcare representative, there isn't something you can't do about it, but you've got to base it on something, a prior discussion with your mother or something like that. And usually if there's never been anything, if my mother hadn't put that in there, we would probably have had to have a conversation with the greater family.
Yep.
To get consensus.
Yep.
And then ask them not to say anything, that only the ones with healthcare representative would be bringing that forward. Yeah. But no, that's usually where it's buried, is inside the healthcare representative. Yeah.
Mark,
Yeah.
I don't know if you can answer that, but at what stage can you still do a representative agreement if there is a dementia diagnosis? That's up to the lawyer? I know that's a legal question.
Yeah. Stephen's the lawyer that I deal with a lot, and we've had those discussions, as a matter of fact. And we've even talked about common clients that are going through that at that point in time. And he's asking my opinion of what I thought of their competency level, where they're at. He has to satisfy himself that they understand what it is they're agreeing to and what the direction was. He was in recently to do a power of attorney for a client, and it was 3 hours. 3 hours sitting with the client, going through it all, before he felt the client understood what it was he was signing, and the client agreeing with him that he understood, and he was able to get him to sign it. So, especially with dementia patients, because we all know that that can change so much from one day to the next as to what they understand and what they don't understand. I had a client who in 1999 was on early onset dementia. She was only 61 at the time. And I found her, I ended up meeting up with her. I forget the circumstances that I connected with her, but I felt she was doing very well that day. It was a beautiful sunny day. And so I asked her if she wanted to go see the notary public to deal with this power of attorney. She said, okay. I said, you understand what we're doing? Yeah, let's go do it. Took her in. She was going to, and my discussions with her was to get her daughter to be the power of attorney for her. And when the notary came out, I said, you got it all done? He said, yeah, got it all done. I'm happy that she understood what she was doing. And I ended up with the power of attorney, not the daughter. That wasn't the plan. But the daughter was okay with that. She was okay in that circumstance because she was just happy that it was done so that we could deal with stuff and help manage her affairs while she was in this state. In fact, she ended up going into Fairhaven back in 2001. So for care, she went into the first floor, locked up area. Yeah, but she was 65 when she went in.
Wow.
Very young. Yeah.
Mhm.
So I've been dealing with these kind of issues for a long time now. Sometimes time goes by so fast I don't realize how long I've been dealing with stuff like this. So yeah. Yep.
I'm sorry, I keep thinking of situations here. The requirement for the representation agreement only became a requirement in the, I think, the 90s or whenever it came into play. But my mom had, I had power of attorney set up prior to this requirement, and power of attorney actually states that it's an enduring power of attorney. But in recent years, when I've had to, use it and for different things, I'm being told that I need to get a separate representation agreement in addition to that power of attorney.
Yes.
Have you come across that with your clients?
Like I was mentioning earlier, is they've got two power of attorneys here in BC, one for healthcare, one for legal and finance.
Yeah.
And the province it's been around long enough, like you said, in the 90s was when it was introduced. So we're talking about 30 years that they're always looking for that healthcare representative. And it's a very specific document as to what it contains in terms of information. I mean, if there is no healthcare representative, they do fall back on the power of attorney. But if there's a family member that wants to work out who doesn't have any of those kind of authorities, they end up muddying the waters, and they do have authority because there is no representation agreement. Yeah.
Okay.
But that's all a legal issue. You got to talk to lawyers about it. So
yeah, okay.
I know enough to get myself in trouble. Yeah.
Okay, great.
No.
So I think we've got a few minutes to spare, but thank you, Mark, for coming in to do this. It was really informative, and so like I said, it gives us lots of things to think about and consider. So I hope everybody found this helpful as a launching pad to think about your affairs.